In the previous video, we have discussed Section 53A of the Transfer of Property Act 1882. If you have not seen our previous video, we have provided the link in the description box which you can check it out. In this video, we are going to study Section 54 to 56 of the Transfer of Property Act 1882, which deals with sales of immovable property. So let's start the video. Sales of immovable property. Section 54 of the Transfer of Property Act defines sale as sale is a transfer of ownership in exchange for a price paid or promise or part paid and part promise. Sale how made? Such transfer in case of tangible immovable property of the value of 100 rupees and upward, or in the case of a reversion or other intangible thing, can be made only by a registered instrument. In the case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by a registered instrument or by the delivery of the property. Delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in the possession of the property. Contract for sale. A contract for the sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest in or search on such property. Thus, the transfer of property may be by means of lease, gift, mortgage, will, or sale, or by any other mode wherein the interest of the property is sought to be transferred. The word transfer cannot be limited in its uses, excluding the sale. The definition of transfer as defined in the Transfer of Property Act means an act by which a living person conveys property in present or in future to one or more other living persons. And to transfer property is to perform such act. Sale is defined as a transfer of ownership in exchange for a price paid or promise, or part paid and part promised. Such transfer in case of tangible immovable property of the value of 100 rupees and upward, or in the case of reversion or other intangible things, can be made only by a registered document. The word transfer as defined under the Act is an inclusive definition. That is, it includes sale as well as agreement for sale. Although an agreement for sale under the Transfer of Property Act is not a transfer, and the rights, title, or interest in the land does not pass until the sale deed is executed and registered. Thus, a sale means a transfer of the right of ownership in exchange for a price paid or promise, or part paid and part promise. A sale of immovable property of the value of rupees 100 or upward may be made either by a registered instrument or by the delivery of possession of the property. The phrase transfer of ownership is significant, as signifying that in a sale there is an absolute transfer of all the rights in the property sold. There cannot be a sale unless there are two distinct individuals, such as the seller and the buyer. Thus, a sale is a number 1 transfer of ownership, number 2 such transfer must be in exchange for a price, number 3 such price may be paid or promised, or part paid and part promised. Essentials of sale. The following are the essentials of sale. Number 1. Transfer of ownership. Transfer of ownership is the transfer of all rights in the property. Number 2. Exchange for a price. In the transaction, price is also provided in exchange which may be paid, promised, or part paid and part promised. The following are the elements of sale. Number 1. Parties. There are two parties in a sale. Number A, seller. Number B, purchaser. Parties should be competent to make a contract according to Section 11 of the Contract Act. Means they should be of sound mind and must have attained majority. Number 2, object. There must be a immovable property and a person should be the owner of the same property. An immovable property can be tangible or intangible. Number 3, cost. Price is compulsory for any sale. It can be paid or promised or part paid and part promised. Number 4, conveyance. Sale is transfer of ownership. Property must be transferred from seller to purchaser. Number 5, registration. In case of all intangible immovable property of any cost or tangible immovable property of cost more than ₹100, registration is required. Difference between sale and contract of sale. Number 1. A sale of an immovable property is the transfer of ownership, whereas a contract for sale is merely an agreement for the sale of property in future on terms agreed between the parties. Number 2. A sale conveys a legal title to the purchaser because absolute interest of the vendor passes to the purchaser. A contract of sale does not convey a legal title to the purchaser. Number 3. A sale creates a right in rem, whereas a contract of sale creates a right in personam. Number 4. A sale requires a compulsory registration where the sale is of tangible immovable property of ₹100 or more. A reversion and any intangible thing, whereas a contract of sale does not require any registration. Difference between sale and exchange. Following are the difference between sale and exchange. Number 1. In a sale, the price is paid in money, while in an exchange, one specific property is transferred for another. Number 2. Sale is always for price, which means money or the current coin of the realm. But no price is paid in exchange, but one specific property is transferred for another. However, in a transaction of exchange, money may be added to the property or goods to equalize the consideration. Section 55 of the Transfer of Prperty Act sets forth the rights and liabilities of the buyer and the seller. There is a clear distinction between the rights and the liabilities before the completion of sale and rights and liabilities after the sale. The former are contractual. The latter are regulated by the rule that property having been passed to the buyer, the transaction cannot be avoided. Thus, the liability of the sellers before completion of sale are: number 1, to disclose material defect in the property or in the seller's title therein. Number 2, to produce title deeds in the seller's possession or power for inspection. Number 3, to answer question as to property or title thereto. Number 4, to execute conveyance on payment or tender of price and tender of conveyance. Number 5, to take care of the property. Number 6, to pay outgoings such as public charges, rent, interest on encumbrance. The following are the buyer's liability before sale. Number 1, to disclose fact as to nature and extent of seller's interest, materially increasing value of which buyer has information, but seller probably is unaware. Number 2, to pay or tender purchase money. The right of the seller before completion of sale to take rent and profit of the property. The right of the buyer before completion of sale to charge for price prepaid. The following are the liabilities of the seller after sale. Number 1, to give possession on being so required. Number 2, implied covenant for title. Number 3, to deliver title deeds in his possession or power on receipt of full purchase money. The following are the liabilities of the buyer after sale. Number 1. To bear loss arising from destruction, injury or decrease in value which is not caused by seller. Number 2. To pay outgoings. Rights of the seller after sale. Charge for purchase money not paid. Rights of the buyer after sale. To get benefit of any improvement or increase in value and rent and profits. Marshalling by subsequent purchaser. Section 57 of the Transfer of Property Act says that if the owner of two or more properties mortgages them to one person and then sells one or more of the properties to another person, the buyer is, in the absence of a contract to the contrary, entitled to have the mortgage debt satisfied out of the property or properties not sold to him, so far as the same will extend, but not so as to prejudice the rights of the mortgagee or persons claiming under him or of any other person who has for consideration acquired an interest in any of the properties. Thus, if the owner of two or more properties mortgages them to one person and sells one or more of the properties to another person, unless there is a contract to the contrary, the buyer is entitled to satisfy the mortgage debt out of the property or properties not sold to him, so far as the same will extend, but not to prejudice the rights of the mortgagee or person claiming under it, or any other person who has acquired an interest in any of the properties. The rule in section 57 applies in the absence of a contract to the contrary. For instance, one of the two properties subject to mortgage is sold, and it is agreed in the sale deed and in the deed of agreement executed by the buyer that in case it is necessary to pay to the mortgagee more than that has been left with the buyer will pay the excess. This stipulation amounts to a contract to the contrary. To take an example, suppose property X, Y, and Z are subject to mortgage. The mortgagor sells X to A from encumbrance. A is entitled to insist the mortgagee should realize his mortgage money out of the properties Y and Z as far as possible. In case the whole of the debt is not capable of being released from Y and Z, the mortgagee has a right to proceed against X. In that eventuality, the purchaser has a right to claim from the mortgagor the amount realized from X.